there is a case pending now that some of you may be familiar with. It's the RealPage matter. And this hit the headlines in October of 2022 when ProPublica launched or published an article alleging that many of the nation's largest rental companies, so companies that control large apartment blocks and then rented them out, were using a pricing algorithm that was developed by a company called RealPage. And so the algorithm that they were using, that RealPage had developed and was selling to them, allegedly resulted in market-wide super competitive rents. And so again, this is all allegations. It's based on the article, but not surprisingly, there was a flood of class action lawsuits that followed, and those have now been consolidated in an MDL in Tennessee, I believe. And basically, at a high level, what the plaintiffs are alleging is that the RealPage algorithm has access to each subscriber's competitively sensitive rent information, reviews that information. That's what AI does. It looks for patterns in vast quantities of data. And then the algorithm generates a predicted or recommended rent for the people who are using the algorithm. And so the basic, it adds a hub and spoke quality to it, basically. The idea is that each of these companies were using the same algorithm facilitated by RealPage, that each competitor was sharing with RealPage or giving access to the algorithm anyway, its competitively sensitive rents. And then the algorithm would turn around and recommend a price that, according to plaintiffs, was accepted virtually all the time. So it's, again, an idea where the companies on the rim may not have agreed with each other to align on rents, but by virtue of this algorithmic pricing technique, they nonetheless resulted in stabilizing rents. And plaintiffs have alleged, in fact, that in affected markets, it wouldn't be surprising to see rents at super competitive levels and actually some level of vacancies in units, the algorithm having predicted that it would be beneficial to leave some units vacant to sustain or basically hinder the supply so that you could get more on the units you were renting, which you might not expect to see in a competitively sensitive market, according to plaintiffs. Now, there's defenses to all this, and again, we could spend a lot more time on it, and the defendants certainly have made vigorous defenses to this in their motion to dismiss the complaint, which is just now getting briefed. But basically, they claim that there's no actual allegations, of express agreement among the companies on the rim, and that even any allegations of circumstantial evidence of agreement aren't well alleged, that there's none of the plus factors you might need or parallel conduct that you must need in conduct with that type of theory. So we'll see what happens there. The court has to decide that motion, and that will reveal some insight into at least how that court is thinking about this type of problem, where you have an algorithm allegedly being used without express consent or express agreement to nonetheless standardize pricing across a market. There's a case in Nevada that is similar, and that involves hotels on the Strip that are allegedly using a very similar technology to an algorithm that then recommends pricing for hotels that are participating in the algorithm. And it's the same basic idea that by virtue of using this same algorithm, the net effect, the market-wide effect, is an increase in pricing above what you might see in a market where there was no algorithm coordinating pricing. Again, all this is up in the air. The defendants, as I said earlier, vigorously dispute the allegations. In fact, they point out in many cases, you don't have to accept the algorithm's recommendation, and sometimes the recommendation wasn't accepted. That there was substantial variance in the pricing that resulted in markets, so there was no parallel conduct at all to begin with. All of that will have to come out in the wash, and we'll see how it develops. But at a high level, and forgive me for rambling on here, but I think the core point is that it is different than Amazon, right? The Posters case, where you had, again, allegedly an express agreement that was implemented by virtue of an algorithm. Here, it's more in the tacit arena, where there's not necessarily good allegations of an express agreement, but the idea is that by using these algorithms, you nonetheless resulted in coordinating pricing.